When we have to prove a fact, we may prove it by an oral evidence or through a documentary evidence. The law with respect to oral evidence I have already covered in my previous video, the link to which I will be sharing in my description box. Today, in this session, I will be covering how to prove a fact by a documentary evidence. This is also called as rule of best evidence or the rule of exclusion of oral evidence. And sometimes we also call it as principle of exclusivity of a document. Hi, I'm Mrs. Kritika Singh. It's been over a decade that I have been helping and supporting students to crack Judicial Services Examination. Before we start today's session, please take a notebook, a pen, and a Bare Act of Indian Evidence Act and take a lot of notes. I will be covering how to prove a fact with a document, which is covered under Section 91 of your Indian Evidence Act. So if we open Section 91 of our Indian Evidence Act, the long title states the exclusion of oral by documentary evidence. Exclusion of oral by documentary evidence. So if we look into the long title, which states the exclusion of oral by documentary evidence, it states that a fact cannot be proved or a fact should be proved by documentary evidence only, and the oral evidence should be excluded. In what cases? In cases which are mentioned under Section 91. In those cases where a fact has been recorded in form of a document. So it is covered under Chapter 6 of your Indian Evidence Act, which states the exclusion of oral by documentary evidence. अगर आपने किसी फैक्ट को एक डॉक्यूमेंट में रिकॉर्ड किया है तो फिर आप ओरल एविडेंस नहीं दे सकते हैं, वो एक्सक्लूड किया जाएगा. Oral evidence will be excluded by documentary evidence. Now, if we look what Section 91 states, it states evidence of terms of contracts, grants, and other dispositions of property reduced to the form of a document. When the terms of a contract or of a grant or of any other disposition of property have been reduced to, please underline, have been reduced to the form of a document. We are going to study Section 91 in two parts. This is the first part, which states that a contract or a grant or any other disposition of property which has been reduced to the form of a document. And second part says, and in all cases in which any matter is required by law. So it is required by law to be reduced to the form of a document. So these are the two different parts of Section 91. And the rule given by Section 91 is that in such a case, no evidence shall be given in proof of the terms of such contract. So underline no evidence. कोई भी evidence नहीं दिया जाएगा. No evidence shall be given. Shall means mandatory. It is compulsory कि कोई evidence नहीं दिया जाएगा while proving the terms of such contract, grant or other disposition of property or of such matter except the document itself. सिर्फ और सिर्फ वही डॉक्यूमेंट से हम जो है उस कॉन्ट्रैक्ट, ग्रांट और डिस्पोजिशन को हम प्रूव करेंगे. और सेकेंडरी एविडेंस ऑफ इट्स कंटेंट्स इन केसेस in which the secondary evidence is admissible under the provisions herein before contained. So it states, or we may also prove the document by secondary evidence. Secondary evidence is covered under Section 63 of your Indian Evidence Act, and the circumstances in which the secondary evidence can be given are covered under Section 65 of Indian Evidence Act. So in only those circumstances, a document can be proved by a secondary evidence. So now let's understand this section in detail. Let's say there is a fact. Now, as per Indian Evidence Act, this fact should be a relevant fact. That means it should be covered from section 6 to 55. It should be covered under section 6 to 55 of Indian Evidence Act. तभी हम उस फैक्ट को जो है कोर्ट में प्रूव करेंगे. और रेलेवेंट फैक्ट को जब हमने प्रूव करना है, नाउ वी हैव टू प्रूव दिस रेलेवेंट फैक्ट. वी आर गोइंग टू प्रूव द रेलेवेंट फैक्ट ईदर बाय द ओरल एविडेंस, या तो विटनेस कोर्ट में आएंगे और बयान देंगे, या फिर हम डॉक्यूमेंट के थ्रू उस पर्टिकुलर फैक्ट को प्रूव करेंगे. और एक तीसरी कैटेगरी है, दैट इज रियल एविडेंस. ऑन दिस आई हैव मेड अ डिटेल्ड वीडियो, that is the introduction to the Indian Evidence Act. So in that video, I have discussed this concept in detail. So I'm just trying to connect you with today's topic. That's why I'm just giving you a little background to it. So now, if we have to prove a fact and that fact is reduced into probably a document, in that case, we have सेक्शन 91. अगर हमने उसको डॉक्यूमेंट पे रिड्यूस, अगर हमने एक फैक्ट को डॉक्यूमेंट नहीं किया है तो हम उसको ओरल एविडेंस से प्रूव करेंगे. बट अगर हमने एक फैक्ट को लिख लिया है, उस केस में सेक्शन 91 कहता है कि ओरल एविडेंस विल बी एक्सक्लूडेड एंड इट शुड बी ओनली प्रूव्ड बाय द डॉक्यूमेंट इटसेल्फ. सेक्शन 91, इसको हम बेस्ट एविडेंस रूल भी कहते हैं. बेस्ट एविडेंस रूल. वी ऑल्सो कॉल इट एज रूल ऑफ एक्सक्लूजन ऑफ ओरल एविडेंस, एंड समटाइम्स वी ऑल्सो कॉल इट एज द प्रिंसिपल ऑफ exclusivity of document. Now, as we read section 91 from the Bare Act, and we divided section 91 into two parts. So the first part of section 91 states that there was a contract. There was a contract, comma, grant or other disposition of property. So what is a contract? Now we have to understand these terms, that is contract, grant or disposition of property. So what is the meaning of contract? Contract is a document which is fulfilling the essentials of Section 10 Indian Contract Act. Section 10 of the Indian Contract Act states that an agreement will become a contract if the essentials of Section 10 are being fulfilled. That means there was a free consent, there was a lawful consideration, a lawful object, parties were competent to contract, an agreement was not declared to be void by the Indian Contract Act, there was an offer, there was an acceptance. So only then a contract comes into picture. So if there is a contract or there is a grant can be a gift. But remember that it will not include will. Not will. Why it will not include will? It is an exception. Because in case of will, the will takes effect only after the death of the person who has created the will. It comes into operation on the death of the person who has created the will. So that's an exception. So the will not be covered here. And the other disposition of property, where you're disposing of the property in any other method, like let's say sale, let's say mortgage, all those cases are examples of disposition of property. Now, that was the first element of section 91. The second element or the second ingredient is reduced in the form of a document. Now, here it is very important to understand that this contract, grant, or other disposition of property is reduced in the form of a document not because the law requires, but because party has reduced it in a form of a document voluntarily. Meaning thereby कि ये जो कॉन्ट्रैक्ट है अगर ओरली हो सकता है तो पार्टीज उसको ओरली भी एग्जीक्यूट करवा सकते हैं. अगर वहां पे इट इज नॉट रिक्वायर्ड बाय लॉ to be in written, in that case it can be oral also. Contract can be oral or contract can be written also. So in the first part it is very important that the contract, grant, or other disposition of property is reduced in the form of a document not because it is required by law, but it is reduced in the form of a document because the parties have reduced it in the form of a document. So here if a particular contract, grant, or other disposition is not reduced in the form of a document, because यहाँ पे discretion दे दिया है, या तो आप उसको डॉक्यूमेंट कर दो, लिख लो, या फिर आप उसको डॉक्यूमेंट नहीं बनाओ. In that case, if you have reduced it into the form of document, if yes, in that case, section 91 will apply. And if you have not reduced it in the form of a document, in that case, oral evidence can be given. Oral evidence can be given. And what you have reduced in the form of a document is the third part or the third essential that states the terms of the contract, the terms of the contract, grant, or other disposition. Other disposition. Now, what is a term of a contract? Term means something which is material to the contract. So, जो आपने कॉन्ट्रैक्ट किया है, जो दो पार्टीज ने कॉन्ट्रैक्ट बनाया है, उसका जो मटेरियल पार्ट है, that you have reduced in the form of a document. अगर कोई ग्रांट है, कोई गिफ्ट है, या फिर और कोई मेथड है जिससे आप प्रॉपर्टी को डिस्पोज ऑफ कर रहे हो, उसके जो टर्म्स है आपने उसको वॉलंटरली इन द फॉर्म ऑफ अ डॉक्यूमेंट रिड्यूस किया. सो इफ यू हैव रिड्यूस्ड इट इन द फॉर्म ऑफ अ डॉक्यूमेंट, इफ इट इज यस, you have reduced it, then in that case the document itself can only prove the terms of the contract, grant, or other disposition. So the law states the document itself is allowed. And this is the primary evidence. इसको हम कहते हैं primary evidence. इसको हम कहते हैं best rule of evidence. But sometimes it might happen that you may lose the document. The document is lost or it is damaged and you don't have the possession of the document. In that case, we will have to only prove that document by secondary evidence. That's the first key. And the second key is you may also prove it by secondary evidence. So secondary evidence क्या होता है? Section 93 of your Indian Evidence Act, read with Section 95 of your Indian Evidence Act. So the first part is simply stating or giving us a rule that if there is a contract, grant, or other disposition of property and it is reduced in the form of a document, not because it is required by law, but the parties have reduced it into the form of a document, in that case, the terms of the contract, grant, or other disposition will only be proved by the document itself and no other evidence will be allowed. But yes, in case the terms of the contract, grant, or other disposition cannot be proved by the document itself, in that case, we may also prove it by secondary evidence. The secondary evidence is covered under Section 93 of your Indian Evidence Act, read with Section 95 of the Indian Evidence Act. So that was the first part of Section 91. The second part states, second part of Section 91 Indian Evidence Act. Any matter required by law. Now here it is required by law. Any matter required by law to be reduced in a form of a document. Now here, if any matter is not, because the parties are wishing to reduce it into the form of a document, but here it is a mandate. It is required by law to be reduced in the form of a document. अब ऐसे मैटर को अगर आपने डॉक्यूमेंट किया है, in that case, the Section 91 states that it can be proved by the document only, or it may also be proved by a secondary evidence. Secondary evidence. Which is given under Section 63, read with Section 65 of your Indian Evidence Act. So we have two options, either to prove the document which is required by law to be reduced in a form of a document by the document itself, or by secondary evidence. Secondary evidence, Section 63, read with Section 65. 65 gives us the circumstances where the secondary evidence will be allowed. Now, that was a simple Bare Act interpretation. Now, if we dive more into this concept, now we have to understand that if there is a contract or a grant or other disposition of property, now it may be required by law to be reduced in writing, by law to be reduced in writing, or it may not be required by law to be reduced in writing. It's very important that when you read a Bare Act that you identify that whether the term or is used or and is used, and accordingly interpret the provision. Now, if there is a contract, grant or other disposition of property and it is not required by law to be reduced in writing, in such a case, we will also examine the provisions of Indian Registration Act. And if the Indian Registration Act states that in spite of a particular contract, grant or other disposition not required by law to be reduced in writing, but if Section 17 of the Indian Registration Act requires such document to be registered, then it is required that such contract, grant or disposition, I'm just using the short forms, CGD, contract, grant or disposition, then it is required that such contract, grant, or disposition should be documented. Because if you don't have the document, you cannot get it registered, na? And also, Section 17 further states that oral evidence will not be allowed. Oral evidence will not be allowed. That means, as we discussed under Section 91, first part, that if there is a contract, grant, or other disposition of property, and if it is not required by law to be put into a document, or it is not required by law to be reduced in writing, but if Section 17 of the Indian Registration Act states that such a document is required to be registered, उसकी registry होना जरूरी है, then in such a case, the document can only be registered if it is in a written form. So, if a contract, grant, or other disposition of property is required to be registered, it should be documented and the oral evidence will not be allowed. What is the process of registration? The process of registration I have given a very simple formula for it, which is DEAR. That is, the document can be registered or a draft can be registered only if it is documented, then it is executed, attested, and then registered. On this also, on the process of registration also, I have made a video. You can subscribe to my YouTube channel and explore a lot of videos and get a lot of value to yourself with respect to law. Now, the next question is that if a document is required to be registered, but if it is not registered, what would be the consequences? The consequences are given under Section 49 of the Indian Registration Act. And Section 49 of the Indian Registration Act states that if a document is required to be registered and it is not registered, it cannot be proved under Section 49 of the Indian Registration Act. So basically, we have two sections of Indian Registration Act, that is Section 17 of the Indian Registration Act, which gives us the list of those documents which are required to be registered, and Section 49 gives us the consequences that if those documents are not registered, what would be the consequence? The consequences are that it cannot be proved, and it gives us the documents which are required to be registered. Now, can I say that Section 91 of the Indian Evidence Act is contradicting Section 49 or Section 17 of the Indian Registration Act? Because if we look into Section 91, Section 91 states that if there is a contract, grant, or other disposition of property, and if it is not reduced in the form of a document, it can also be proved by an oral evidence. It can be proved by an oral evidence. Now, if a document is, let's say this is a document, and it is reduced to writing. Let's say this is a document and it is reduced to writing. But if it is not registered, in that case, Section 91 कहता है कि अगर राइटिंग में है ना तो आप डॉक्यूमेंट से प्रूव कर सकते हो उस पर्टिकुलर डॉक्यूमेंट को. बट इंडियन रजिस्ट्रेशन एक्ट कहता है, IRA कहता है कि अगर वो डॉक्यूमेंट रिटन में भी है, बट इफ इट इज रिक्वायर्ड टू बी रजिस्टर्ड और आपने उसको रजिस्टर नहीं किया है, तो सेक्शन 49 कहता है कि आप उस डॉक्यूमेंट को प्रूव ही नहीं कर सकते. इज देयर अ कॉन्ट्रडिक्शन बिटवीन द टू? आई रिपीट, if there is a document, let's say this is a document, and ये document क्या है? It may be a contract, it may be a grant, it may be other disposition of property, and it is reduced to writing. It is reduced to writing. In that case, where it is reduced to writing, Section 91 of the Indian Evidence Act states कि हम इस document को prove कर सकते हैं by the document itself. But Indian Registration Act कहता है कि अगर आपने एक document को लिखित में भी लिया है ना, but अगर वो required है कि वो registered हो और आपने उसकी registry नहीं करवाई है, तो Section 49 of your Indian Registration Act states that such a document cannot be proved. Consequences. वो क्या consequences है? Consequences है कि written document, but if it is not registered, in that case the consequences are that such a document cannot be proved as per Section 49 of your Indian Registration Act. There is no contradiction, but we read these two provisions, that is Section 49 of the Indian Registration Act and Section 91 of the Indian Evidence Act in harmony. And the combined effect of Section 49 of the Indian Registration Act and Section 91 of the Indian Evidence Act states that neither the documentary evidence can be given nor a oral evidence can be given if a document is required by Indian Registration Act to be registered, except in the cases where the suit is for the specific performance of a contract, or if a suit is to prove a collateral transaction, or if a suit is to prove the collateral transaction. All this is given under Section 49 of the Indian Registration Act. You may open your Bare Act, look into Section 49 of the Indian Registration Act, and you will see the details with respect to documentation, registration, and the exception with respect to specific performance and proving of a collateral transaction. Before I wind up today's session, there is a question for all of you, the answer to which you can share in the comment section, that if there is a confession is required by Section 164 CRPC to be reduced into writing, and if it is not reduced into writing, can it still be proved? And if it is not reduced into writing, can the party give oral evidence on it? I would like to hear from all of you. Thank you for watching. Subscribe to my YouTube channel for more informative videos like these.